Good morning. This is the License Commission hearing. It is Wednesday, June 17th, 2015 at 9:37 a.m. We're in the Michael J. Lombardi Building, 831 Mass Ave Basement Conference Room. Before you, the Commissioners, Chair Andrea Jackson, Chief Gerald Reardon, Commissioner Robert Haas. We have two matters on this morning. The first one is a report on an investigation that was conducted. I think we'll start with that. I didn't do my cell phone talk, no.
I'm going to be recording.
Okay. So we'll start first with the investigation. We can have counsels.
One minute, Chair. Well,
Give me 1 second, I'll let everybody get some. No worries, Steve, you'll get here when he gets here.
Who's going to?
Marilyn Cobbs.
M.A.R.
M.A.
I'll have him on.
M.A.R.I.L.Y. Marilyn Carter. K-A-P-S-A-L-I-S.
Good morning, all.
Good morning.
If I can have everyone please introduce themselves, starting with Mr. Rafferty, first name, last name, and spelling for the record, please.
Good morning, Madam Chairman of the Commission, James Rafferty, R-A-F-F-E-R-T-Y, appearing on behalf of the licensee Capsco Inc. To my right is Marilyn Carter, C-A-R-T-E-R. She's the current manager, and she is petitioned to have stock transferred to her.
Stephen Kapsalis, K-A-P-S-A-L-I-S.
Walter Sullivan on behalf of Stephen Kapsalis, S-U-L-L-I-V-A-N.
Thank you.
So the commission received an anonymous complaint that was forwarded to us from the police department. The chair asked Michael Gardner to conduct an investigation on behalf of the commission, as we really don't have sufficient amount of staff to accomplish what we felt was going to be a rather in-depth investigation. There were a series of allegations. The police department handled one of them, which dealt with falsification of signatures on a petition, and as a result of that, criminal charges were brought. The report does say there was an indictment of an individual. That's not correct. There was no indictment. The remaining allegations were forwarded to us, and those I can read out for you. It was falsification of an application for a package store license on March 1st, 2005, with the claim that 3 questions were answered incorrectly or untruthfully, granting a beneficial interest in a liquor license to numerous restaurant tenants without license commission approval while operating a separately owned cash bar only in the basement, renewal of licenses without disclosure of convictions, without disclosure of beneficial interest transferred to restaurant tenants, and without disclosure of alteration of premises, closing and renovation of the restaurant without permits, inspections, or license commission approval, opening a new restaurant without permits, inspections, or licenses. So one of the main allegations is that Mr. Kapsalis and his corporations had ownership interest in a Section 12 and a Section 15 and Section 12 and Section 15 licenses, which is a probable violation of General Laws, Chapter 138, Section 17, which prohibits a single individual from holding both a license to serve alcohol at a restaurant and a license to sell alcohol as a package store.
Within the same city.
Within the same city, yes. I'm just summarizing from the report.
I apologize.
As a result of that, I consulted with the ABCC. After hearing back from the ABCC, we were advised that Mr. Capsalis needed to transfer one of the licenses. We scheduled a hearing to do that. We will be acting, I believe, on that. The board will be acting on that petition subsequent to this agenda item. Prior to acting on the petition, the commission had determined that it needed further information, and that brings us to where we are today. So Mr. Gardner, in conducting his investigation, I'll talk about his methodology. He reviewed correspondence that Ms. Jackson provided to him. He reviewed relevant files of the License Commission, transcripts of commission hearings, audio tapes from the 1980s, legislative history of the relevant case law, the Cambridge Rent Control Statute, which was Chapter 36 of the Acts of 1976. He interviewed License Commission staff, inspectional services staff. He conducted telephone interviews with 2 individuals or their counsel. He was sent a detailed list of questions, asked to respond to in writing, which he did. Supportive.
Mr. Capsalis.
Mr. Capsalis, yes. He did respond to them. Supportive documents were requested. Part of the alleged anonymous complaint discussed contractors that might have done work at 991 Mass Ave in late 2014, and he reached out to all of them as well. He did a rather extensive history and background of the licenses. There's no question that these licenses have been held either by Mr. Capsalis' father prior to 1984, that he had the restaurant license in 1982 or 83. There are some missing files in the commission because there had been a flood in the storage room and many files were lost. There's no question that he had package store license. There's no question that he had the restaurant license. In all applications to the License Commission, it's determined that, and in hearing transcripts, it was determined that at all times it was very forthcoming in that regard. So I would first discuss the review of the allegations in light of the facts that developed based on the history, and as I said, it was a very detailed history going back to the very first license and moving forward. Mr. Gardner determined that it seemed clear there was a violation of Chapter 138, Section 17, prohibiting ownership by the same individual in the same city. I'm sorry, I just want to make a note. By having both the package store license and the restaurant license. It appears that was violated briefly in 1997 after there was a transfer from Gemini and before the transfer to the University Wine at Harvard Square, and then an ongoing basis since 2005. However, Mr. Gardner goes on to say it's very clear there was no intent on the part of Mr. Capsalis to hide his dual license ownership. Information about his license for the Cellar was included in his application for the package store in 2005. His counsel, who was Mr. Rafferty at the time, was forthcoming in citing it in Mr. Capsalis' presentation to the Commission in both 1997 and 2005. He concludes at that time, he concludes that issuance of the dual licenses appears to be an innocent mistake, and in fact, the Commission's granting of the license was also approved by the ABCC. There's also precedent by the License Commission on in at least 3 separate situations where the Commission has become aware of a possible violation of General Laws Chapter 138 and 17 for holding licenses under both Section 12 and Section 15. Mr. Gardner does go into great detail explaining those. I can briefly summarize them if you like, Madam Chair.
Very forward, please.
Yeah. But I would start out by saying It's always been the policy of the board to work with licensees and not punish them in these situations where it's been inadvertent or basically the fault of the board and the ABCC in allowing the approvals. So one of the examples was Libby's Liquor Market and Dome Package Stores, as well as ownership of the Restaurant Cafe of India. When it was determined, I think that was the first situation back in 2008 that the commission dealt with this situation. The chair at the time was Richard Scally. I believe Commissioner Haas was here, and Deputy Fire Chief Turner was representing the fire department. The situation went on for well over a year in trying to determine what the best way was to dissolve ownership of one of the in one of the corporations. I think it was the restaurant that they ultimately changed ownership of. That transfer was allowed by the board and was subsequently approved by the ABCC. The same situation occurred with the Blue Room and Central Bottle, where ownership, two of the owners of the Blue Room became part owners of Central Bottle. Well, one of them was on both licenses. It was determined that would be a violation, and they were allowed to get rid of their ownership in that. And then there was most recently Lulu Cuisine and High Rise Bread Company, and the owner of High Rise was able to transfer his ownership to his wife, who was also part of the business. Do you want any more than that?
No, thank you.
I'm going to move to allegation of falsification of application for a Section 15 package store license. Mr. Capsalis is accused of being untruthful when he responded no in his 2005 application as to whether he had ever been convicted of a federal, state, or military crime. That was one of the questions that Mr. Capsalis was asked by Mr. Gardner. And he answered that as reflected in the transcript of the October 22nd, 1985 License Commission hearing, he stated, "I was convicted of violating certain provisions of the Cambridge Rent Control Ordinance." He went on to discuss that. I'm not sure it's appropriate to put that all on the record.
Madam Chair,
Yes.
I apologize again, I didn't mean this one. Thank you very much. The question that this commission asked, and that all is relevant, I believe, and please correct me if I'm wrong, was that, did Mr. Capsalis answer the question truthfully? Mr. Gardner goes into length of a whole bunch of issues that go well beyond what this commission asked. So I respectfully request that Ms. Lint only give the response relative to Mr. Capsalis answering the question truthfully or not, and nothing further. If you do decide to go further, I would respectfully request that the hearing be closed to the public as a result of criminal, talks about a criminal conviction and my client's right under that law, under the Corey law, relative to disseminating information to the public.
I would say based on both Mr. Gardner's investigation as well as Superintendent Burke's investigation regarding those types of convictions, his response was found to be accurate as stated. In addition, the License Commission at the time of the application for the package, was it the package store?
Yes.
Yeah. The License Commission was well aware of the municipal violation. And in addition, the result of which occurred after his application had been filed. So at that time, the application was approved. He's also accused of being untruthful in answering no to question 12 on March 1st, 2005 application for the package store license. The question is, do you own the premises? In this instance, Mr. Gardner determined it was a matter of corporate identity. The package store application was being made on behalf of Capsco Inc. Capsco Inc. does not own the premises at 991 Mass Ave. Mr. Capsalis does. So in he did properly answer the question by elaborating in his answer, identifying himself personally as the owner. There's no ambiguity or untruthfulness in his answer. He's also accused of being untruthful in answering no to question 14C regarding whether a person or entity listed in question 14 ever held a license or beneficial interest in a license issued under Chapter 138, which is not presently held. Mr. Gardner's conclusion here is that Mr. Capsalis is the person listed in question 14 as having a direct or indirect beneficial or financial interest in the license being applied for. In this instance, it appears his answer, no, is inaccurate. Capsco, of which he was 100% owner, briefly held the same package store license in 1997 after having received it from Gemini and prior to selling it to University Wine Shop at Harvard Square, Inc. He also held the beer and wine restaurant license attached to the Bigelow restaurant from April '85 until he sold it, apparently sometime in 1990. As Mr. Gardner read the question, he should have answered yes and then elaborated in question 14D. However, he goes on to say this appears to be an innocent or inadvertent mistake. Mr. Capsalis made no effort to hide his prior ownership of the package store, a fact known to the chair of the License Commission, who raised it as an apparently positive factor in support of the application, when the chair at the time said, so you're just going back to what you were before Mr. DeRusso owned it. And that was assented to by both Mr. Capsalis and Mr. Rafferty at the time. The next section is granting a beneficial interest of liquor license to numerous restaurant tenants without license commission approval. This allegation appears to refer to the fact that at least from the fall of 2006 into the fall of 2015, Mr. Capsalis appears to have turned all responsibility and financial control of the restaurant side of the business to third parties. It is not known if he had a similar arrangement prior to the fall of 2006. Apparently this was never reported to the license commissioner. Ms. Carter is listed as the matter of record and appears to have had nothing to do with the operation of the restaurant, though presumably she managed the bar service. And it's apparent that he maintained full control over, Mr. Capsalis retained full control over the liquor license. Whether that's granting a beneficial interest in the liquor license to who was referred to as Mr. Gilson and Mr. Arms is a question that the board at some time would have to consider. The board would then also have to consider what any other restaurants in the city are doing. But clearly, Mr. Arms and Mr. Gilson did not have any interest in the liquor sales. The next section was renewal of licenses without disclosure of criminal convictions, without disclosure of beneficial interest transfer to restaurant tenants, and without disclosure of alteration of premises. So the question here was whether Mr. Capsalis should have revealed his criminal convictions, which we've already dealt with, that it's determined there really weren't. The ABCC approved renewal form, which is their form, does not require disclosure of that information. It requires only that the licensee certified the renewed license will be of the same type for the same premises now licensed. The licensee has complied with all laws of the Commonwealth relating to taxes, and the premises are now open for business, and if not, explain. They also have to certify what entertainment devices are in use and that are for entertainment and not gambling purposes. There was no inconsistencies in the renewal affidavits. Disclosure of beneficial interest transfer to restaurant tenants. It's Mr. Gardner's contention that subcontracting out the restaurant portion of the business should have been reported to the License Commission and obtained License Commission approval prior to implementation of that. So that would have been for both Mr. Gilson and Mr. Arms. Whether or not that's a violation of 138.12A is rather ambiguous based on this report, and I don't know that a determination has been made in that regard. Alteration of premise. This matter was disposed of by the commission at a hearing in September 2000. The premises description from 1985 until 2000 was either inaccurate or ambiguous. Sometime in the late 1990s, the approved bar was moved according to representations made by Mr. Rafferty, who was Mr. Capsalis' counsel at the time, from one side of the room to the other. Mr. Rafferty accepted some responsibility for failing to notify the commission of that change. The commission accepted the explanation, approved the change, and Mr. Gardner feels there's no reason to reopen that matter now. Closing and renovation of a restaurant without permits, inspections, or license commission approval. Neither Mr. Capsalis nor his manager notified the commission of the disruption resulting from Mr. Arm's abrupt departure in November of 2014. However, License Commission Chief Investigator Andrea was reading an article and immediately went down to the restaurant and informed the commission immediately as well as to what was happening at the restaurant. She received assurances from Ms. Carter that the restaurant would be remaining open with a reduced menu while renovations were undertaken. And Ms. Carter took affirmative steps to keep Ms. Boyer and the commission informed. There was definite communication on a regular basis, and I was well informed of it. Although unfortunate disruptions occur in the restaurant business, the commission in this situation acted consistently, as it has in others, to work with the license holder, providing consideration as they attempt to recover operations. It's the commission's interest in ensuring that needed renovations get done to better serve the public. In this particular situation, they were handled very quickly, and the restaurant was restored to full operation in either December or January. Permits. The plumber hired by Mr. Capsalis to replace the sink did not pull a permit as he should have. Ms. Boyer's prompt action corrected that. He got a permit the next day. Subsequent inspections by the Inspectional Services Department found that a dishwasher and some light fixtures had been replaced, work that did require a permit. Mr. Capsalis said he didn't realize that. Late permits were issued by ISD, and Mr. Capsalis was charged a late fee, which basically doubled the price of what the original permit would have been. Subsequent inspections found no additional issues. The party making the accusations identified a number of contractors whose vehicles had been observed outside. Mr. Capsalis was asked about these, confirmed several of them had done work at the restaurant. Mr. Gardner attempted to contact those he said he had not worked with. He was unable to reach all of them. Those he did speak with said they had done no work at that address, and one said he was a milkman and delivered milk in the city, but not to 991 Mass Ave. Opening a new restaurant without permits, inspections, or license. Mr. Gardner concludes the disruption in service was not so lengthy that it amounted to the opening of a new restaurant. The commission encourages renovations when appropriate to ensure proper sanitary conditions and to improve the dining experience for the public. And that basically sums up the report.
So out of all of that, in my opinion, I think that the two issues that I have is just making sure that if work is done in the restaurant, you need to make sure that you pull the permits. Shouldn't require ISD coming in there and finding it. You should be affirmatively taking the steps, and if you're making any modifications, you A, let the commission know, and B, make sure you pull permits. The only other issue for me is as it relates to the work of the chefs in the restaurant, and I'm not sure whether this commission is prepared to deal with it specifically as it relates to Mr. Capsalis, or if this is something we need to be looking at globally across the board, and I'm not sure whether or not we want to be looking into those type of arrangements. And I think that's a board decision, again, not necessarily germane just to Mr. Capsalis, but across the board. So I don't know if you have any other comments, or you have any other comments you'd like to add, or?
Could I just add some context on that, because
Sure.
I participated, as the report indicates, in many years in some of the decisions made here. The issue, just historical context, the issue around having a separate kitchen operation or a subcontract kitchen first became prominent in Cambridge at the old Forest Cafe, which was operated by Mr. Gaudette, a longtime licensee. His father held a license before him. It's in the location now of where Julian or West Side. I think
No,
it's West Side.
No,
I think-
it's Julia. Julia.
Oh, yes, sure. Well, at any rate, Mr. Gaudette contracted with a young chef who provided a Mexican cuisine, and it proved to be very popular. But the food service, and we had conversations, I had conversations with licensed commission staff at the time about that model, but for years, the Forest Cafe had a very popular Mexican restaurant, and I reviewed with them their operations. I did not represent them, but I knew of Mr. Capsalis' interest. That model was then duplicated in Porter Square at the old Porter Cafe, where Spirit is now, where another chef operated a barbecue operation in the kitchen. The longtime family, the Shine family, operated the Porter Cafe. We're talking now in the 80s and the 90s, where that service was provided by another chef who ran the kitchen, collected the meals, but separated from alcohol. So I quite concur, Madam Chair, that if it's a policy, it's a long-standing policy or practice as employees that continues to be employed. I'm not sure what Mr. Arms' current relationship is, but I read that he's now at Passim, which is a licensed establishment in Cambridge. I don't know whether he has the same type of relationship at Passim that he had here, but I would agree that it is something that, if it warrants attention, it should be done on a macro level. And there is a lengthy precedent in past practice and in ongoing operations.
Thank you. Do you have any questions, comments?
No, I agree. I think there's some policy issues that are identified in the report that we're going to have to take at a different form, not this form. And I concur with Mr. Rafferty that with respect to this issue, there is past precedent with respect to that being allowed, long-standing past precedent. But I think it's something that's worth revisiting by the License Commission at some point in the future.
I agree with Commissioner Staples. I'm aware of long-standing issues throughout the city, very similar to what council has talked about. It has to be dealt with. It would be in this form, as the Commissioner said, but we'd have to look at that on a citywide level, not an individual level.
I'm comfortable that Mr. Gardner did a very thorough job investigating the allegations. I don't know if you have anything you would like to add, comment, question?
I mean, as you know, Madam Chair, we sent Ms. Lint an email last night regarding our objections to certain factual errors in that report. Our concern last night was the fact that there was a potential that the commission would be posting this investigatory report online. And as stated, we find it very inappropriate, especially what the report contains, but also it's never been done on behalf of any other licensee. I think with what you said, I don't think there's anything in that report that shows that Mr. Capsalis did anything wrong that would rise to a level of any type of violation hearing being conducted. And that my recommendation would be subject to report being placed in the file and not on file, that the report be redacted, or at least a public copy that be redacted, that my client ensures would not be made available to the public relative to issues of Corey and other information that would not be subject to a public records request.
So noted. based on the report received and comments, I make a motion that we place the matter. Oh, I'm sorry, are there any members of the public that wish to be heard in this matter? Seeing none, I make a motion that we place this matter on file.
Madam Chair, with all due respect, on file has the definition of that you've made a finding and you're placing it on file. In the file as that it's being placed in the file. With all due respect, I request that you rephrase that.
Sure.
So Madam Chair, I think Ms. Lint has read or summarized Mr. Gardner's report. I think the body should take each of these allegations now and make a ruling as to whether or not
Sure.
it concurs with the report or take exception with it or get clarification so that there's some finality with respect to the allegations.
Absolutely, that's fine.
I think just accepting a report doesn't really address what the commission's view is with respect to those allegations.
Sorry. Too late to throw something in?
Yes, at this point, yes. So we can go allegation by allegation, and starting with number 2.
I think that's the appropriate thing to do. I mean, simply placing a Kourafas would not
That's fine.
reflect the commission's view with respect to its findings concerning those allegations.
All right, so let's start then with the first
Madam
claim.
Chair, can I just raise a procedural question? Because this is an area that strikes me as quite unusual. Does the commission intend to, the report contains conclusions, legal conclusions, for which the licensee has not had an opportunity, was only provided a copy of the report within 24 hours of its issuance. It's notable that the one conclusion that jumped out at me was the conclusion around the issue involving the food operation at the restaurant. I found it notable that in all the investigatory work of Mr. Gardner, he never spoke to the manager of record at the restaurant, Ms. Carter. He relied on speculation by Mr. Gilson as to what went on beforehand. But he never inquired how many hours Ms. Carter spends on the premises, what her role is there. But it doesn't strike me that this licensee has been noticed about attending a hearing today to address issues around that management. So I know the report contains recommendations, and if the intention is here as to whether or not to make comment among the recommendation, I suppose that's within the purview of the commission, but to reach into conclusions contained in the report and either affirm those conclusions or otherwise, it feels to me that this feels, I'm not sure what the commission is doing at this juncture. What was done here was an application was filed by Capsco at the direction of the commission based upon advice and direction received by the ABCC. That application has been pending because of an anonymous complaint. Anonymous complaints are given various levels of weight for a variety of reasons, including the absence of one to be able to identify whether the complainant has a bias or prejudice or motives beyond policy. The commission has taken what, in my experience, is an unprecedented step here to retain an outside investigator to conduct this investigation. Frankly, I'm pleased with the conclusions. I think there was a variety of ways they could have been reached, but to the extent the commission felt that that was necessary, I think that's fine. But this strikes me no different than when Ms. Boyer receives a complaint from the police department regarding an incident at a licensed establishment. There's a determination made as to whether or not something should go to the commission for further investigation or hearing. If that's what we have here, which is Mr. Gardner in the role that the chief investigator typically plays, those reports then don't come to the commission and the commission takes votes on Ms. Boyer's recommendations. I think the placing of the report in the file at this point is adequate. Ms. Boyer is chief investigator. If the commission or the chair feels that she needs to further explore this, it would seem to me the commission should work within the infrastructure of its investigatory framework and not turn this morning's hearing into an adjudicatory process about the conclusions in that report.
My only reservation is that then we're taking the report at face value, and that these allegations, for all intents and purposes, then are left out there, and the commission has taken no action with respect to those allegations, right?
No, I don't accept that characterization. If the commission doesn't initiate, if the commission receives allegations
Right.
all the time, anonymous or otherwise. every one of those allegations doesn't then have to get affirmed or rejected. If there's information here to warrant notice and disciplinary proceedings, then the commission makes that determination, not sitting in a public setting, but based on the information they provided. So the mere fact that in anonymous, I think we're stretching the term anonymous, but we're going to go with the notion that these are anonymous complaints. They weren't just given to the police. I have a copy of this, or aware of what was sent to inspectional services. This has been widely disseminated. Why its author chooses not to have their name published is somewhat ironic to me, given the level of publicity that's been attached to this. But having said that, the commission's lack of referring a matter for investigation is action within itself. So if you've received a report, and based on the report there's nothing in the commission's mind that warrants the initiation of an investigation or a discipline, more accurately, you've had your investigation, if there's nothing contained within the report that would cause the commission to notice the licensee to come in for a disciplinary hearing, then that in and of itself is an action. I don't agree that an anonymous complaint requires a vote by the commission.
So placing the report on file, isn't that basically indicating it concurs with the findings of the reports in its totality?
Not, Commissioner, we're requesting that you place it in the file, which is
Right.
not on file. As you know, as a police officer for many years, that a police officer conducts investigations and makes a determination as to whether to proceed or not with that investigation.
Right.
Sometimes they end that investigation. Other times, they go to the Cambridge District Court, or they go to the DA's office and seek indictment to the Superior Court and move forward with a criminal complaint in an adjudicatory process. This commission is sitting in an adjudicatory process relative to violation hearings. For you to take action on these incidents without proper notice to the licensee, totally different than you've always handled cases in which a complaint comes in the door, goes to the investigation unit conducts an investigation, makes a determination should it move forward or not. You're seeking to skip by a whole process here based on an anonymous complaint.
It seems to me that the commission could conclude that it received an anonymous complaint, it authorized an investigative report, it's received the investigative report. Based on the information in the investigative report, the commission has decided to proceed with the CAPSCO application. We're here today because of the CAPSCO application. Action was deferred to allow for an investigation. If the result of the investigative report is the commission now feels that they can go forward on the CAPSCO application, I think that is the appropriate action for the commission.
Madam Chair, that's what my motion.
Okay. I was just going to add, and I think for me, I highlighted the areas that I had concerns with that I think we need to look at as a board. And with the notion of Mr. Capsalis being informed that if he's going to be doing any type of renovations, making sure the board is aware of it. So in my opinion, that is actually, I guess perhaps in summary, addressing the complaints. And if you feel differently, I'm certainly open.
No.
I agree also that if we take any kind of an affirmative action here today, it would indicate due process to the, we would have to treat this as any other violation and make notice, have a separate hearing. So I'm of the opinion also to place the matter
In the file.
in the file.
And I think that, again, I think a thorough investigation was done. I specifically asked Mr. Gardner to conduct the investigation because I wanted it to be extremely thorough. I knew that the staff would not have time to put the time and effort and the many hours spent into the investigation as he did. And again, for me, I've addressed the concerns that I have as it relates to whatever relationship, as council has addressed, between the restaurant chef and relationships, and then also, again, the whole premise of permitting. So, again, I'll make a motion, it doesn't have to be seconded, but I make a motion to place the matter in the file.
Second.
All those in favor signify by saying aye.
Aye.
So the